Hello and welcome to Landlord and Tenant Board Hearings, What You Need to Know, presented by the Community Advocacy and Legal Center. Today we're going over Notice of Virtual Hearing, how to submit evidence for your hearing, and what the hearing itself is going to look like. The Notice of Virtual Hearing, or NOVH, is a notice that you have a hearing upcoming at the Landlord and Tenant Board. Virtual means the hearing is held by video conference, on Zoom, or by telephone, not in person. You'll receive the NOVH if an application was filed at the Landlord and Tenant Board. If the application was filed through the Landlord and Tenant Board portal, you'll also receive an email to view documents on the portal. The NOVH includes the date and time of your hearing, the file number assigned to the matter, and the Zoom link and toll-free phone number to attend the hearing. Your NOVH also includes instructions on submitting evidence. You can submit evidence by email, mail, or uploading it to the Landlord and Tenant Board portal. To use your evidence at the hearing, you have to send your evidence to both your landlord and the Landlord and Tenant Board. You also have to send it on time, at least 7 days before your hearing. You get an extra 2 days to submit reply evidence if your landlord happens to wait until the last minute to submit their evidence. Pictures, videos, text messages, emails, receipts, city reports, statements from witnesses, and other documents can all be submitted as evidence. You can also ask people if they're willing to join the hearing as witnesses and speak on your behalf. Each hearing has a moderator, mediator, and adjudicator. Moderators keep the hearing organized. At the start, they take attendance and check if you want to try mediation or speak to Tenant Duty Counsel. They're also in charge of assigning people to different breakout rooms on Zoom. Mediators assist tenants and landlords for free in helping resolve the matter. If a consent or payment plan is reached in mediation, the order is binding. If an agreement isn't reached, the parties head to the hearing. The adjudicator is in charge of the hearings. They are members of the Social Justice Tribunal and were appointed by the Government of Ontario to make decisions on applications filed by landlords or tenants. The adjudicator's role is similar to that of a judge in that they hear the facts, consider the evidence, and make a final decision based on this information. When it comes time for your hearing, first, join the Zoom. Give yourself ample time to smooth out any technical issues that may occur before the hearing starts. There will be multiple matters in each hearing block. Wait your turn and have your file number ready for attendance. We also strongly recommend asking for Tenant Duty Counsel when you're signed in. Tenant Duty Counsel are legal professionals you can speak to at the hearing. They can provide free legal advice, represent in some preliminary matters, and help you out in mediation. If you don't want to speak on your own behalf, you can have an agent represent you. An agent could be a lawyer, a paralegal, a friend, or a relative. An agent should have written permission to act on your behalf, and this should be submitted to the Landlord and Tenant Board. When your hearing starts, you and your landlord take turns presenting evidence and questioning each other's witnesses. Whoever filed the application gets to go first. Once everything's been presented to the adjudicator, you should have a chance to summarize your position and any legal arguments you made. The adjudicator will either decide the outcome during the hearing or wait to think on it more. In either case, an order is prepared and mailed or emailed to both parties. You can file a request for review if you disagree with the adjudicator's decision or if you miss the hearing entirely. When you file the request, you can ask the Landlord and Tenant Board to stay the order. This means it freezes or pauses the order until a new hearing is scheduled or the request to review is refused. You must file the request to review with the Landlord and Tenant Board within 30 days of the order. Otherwise, you have to include a request to extend the time. It is not guaranteed that the Landlord and Tenant Board will grant the request. You can file a request to reschedule if you know ahead of time you can't make the hearing. You must include if the landlord agreed to reschedule the hearing, and if you have proof of this, attach it to your request. You also need to list any dates that you're not available for the next 90 days after the original hearing date. You also need to list your reasons why you need the date changed. You have until at least 5 days before the hearing date to do this. All of these forms can be found on the Tribunal's Ontario website under Landlord and Tenant Board Forms. If you have any questions about the hearing process or other tenant and landlord matters, please visit our website to find out more information or feel free to contact us. We are always happy to help.